People against, or Discover Bank versus Artemis J. Petty, 250094. You didn't do that on purpose, right? You would never have done that on purpose. Come on up here, sir. Your name?
Artemis Petty.
I'm not sure what brings you here.
Sir, I have a payment plan with Discover. I am up to date on the payment plan, but we were haggling over the first month. When you made a judgment on this payment in May, I didn't receive.
You got to file a motion. You can't just, did you file a motion?
There's an
Yeah.
objection, Your Honor.
Oh, do I have the other side here?
Yes, Mr. Stratton is here on this, I believe.
Mr. Stratton, come on in, please. Wait a minute, maybe I'm checking, do I have that paperwork, Jen? Objections to garnishment, I see. All right, good morning, Mr. Stratton, your name?
Yep, good morning, Trevor Stratton, P65124 on behalf of the plaintiff.
Your name again?
Artemis Petty.
Okay, so wait a second, did you read his objection? I'm not quite understanding what he said. Do you agree with this? Do you agree with him?
Your Honor, I only heard a few seconds of what he had to say.
Repeat what you said, sir.
I said that I'm here today to, I'm objecting to the garnishment. I am up to date on the payment plan, but they issued the objection due to me not paying the first month in May. And that was due to counsel not sending me the information. Per the paperwork, all of my payments have to have the Weldman Wise account number on it. When I received the paperwork, I started paying. But they felt that because I missed that first month, I'm already in default. Now, I do want to say I made that payment and I just object to that garnishment. And that's the only thing I'm here for. Is to
All right, let me take a quick look at the judgment. Because they didn't send you the paperwork didn't mean that you didn't have to send it right after, right? You should have saved, just hear me a second. You should have saved the money and paid it on a timely basis, right? You agree with that? Can you just agree with that, or you don't want to agree with that?
Yes, I agree, Your Honor.
Okay, fair enough. All right, now let me take a look at the judgment here. All right. So he was to pay $266 commencing on or after May 20, right?
I believe so, yes.
Did he make every other payment except the one back in May of 25?
Not according to the information that I have. Your Honor, I've been given payment information of $266 on 8/4 and 8/25.
8/4 and 8/25?
Right, and $300 on 10/14, and another attempted $300 on 12/3, but returned to NSF.
Is that true?
Your Honor.
Hang on. Don't get angry. I'm just asking.
Nerves. It's nerves, not
Okay.
nerves.
I just want to know, is it true that you didn't make a payment until August 4th? And then that was in the amount of $266, and you made another one on August 22nd in the amount of $266, and you made another one of $300 on October 14th, and that there was an NSF check on December 3rd.
Your Honor, they cost the NSF check.
Wait a minute, wait. I just want to know, is that true that those were the three payments you made?
I've made payments since then too as well.
Hang on a second.
Okay. Also,
Do you agree that you missed your May, June, and July?
no, sir, no, we into the PO box. When they cash them, that's when they cash the check is when they cash the check. These are checks being mailed.
How many checks have you sent?
The checks that you listed are correct, sir.
Well, if these are the checks that you sent them,
Yes, sir.
you're way behind. Right? Come on, guys. I mean, I don't mind. I want to hear you and I want to do the right thing, but I can tell already in 5 minutes, you're going to make me spend 5 minutes asking you questions.
Not at all.
You're going to ultimately admit that you only paid $266 twice and $300 once, and that's not appropriate when the payment amount called for $266 a month starting in May.
You already made a payment of $1,300 as well.
When? That's what I'm asking you. Tell me when.
Yesterday.
What?
So I said I'm up to date, Your Honor.
You're not up to date. See, this is what I love about this job. You know what? They should have, instead of juris doctrine, they should have what are the initials for a dentist, Mr. Stratton? Is it DDS?
EDS, I believe.
That's what they should have, because that's what I am half the time. I'm a dentist. I'm pulling teeth. I knew there was more than this. He's telling me he paid every payment. The only one he missed was your fault because of the May deal.
No, wait, Your Honor, you're not understanding.
Oh, yeah, I am.
No, sir. The reason why, when they garnished me, they took my savings. I had no money to pay. That's why I had to wait till I got paid again. to
You
make the payment,
told
sir.
me when you first came up here, and if you want, I'll have the tape played back, that you'd made every payment except you missed the one in May because it was their fault and they didn't send you the payment information correct early enough. Is that what you told me or not? Am I dreaming?
You're not-
if I-
No, that's what I said.
Well, then come on. I listen. You play games with them. And then you come in, I'm telling you, I'm a dentist. That's what I am. I'm not gonna take your objections to garnishment. I mean, I'm gonna grant his objections. Your objections are invalid. You didn't make the payments time. But next time when you come, if in fact you come in front of me, please don't misrepresent, because it's clear to me that you just did that. And you made me ask a bunch of questions to get to the bottom of it. You're in a courtroom? You're in a courtroom. I don't want to hear anymore. The objections are invalid. Your writ can continue. All monies withheld are to be turned over to the plaintiff attorney. Anything else, Mr. Stratton?
No, Your Honor.
You can prepare your order. Go
Are you
ahead.
allowed to still continue garnishing?
Yes, because your objections were invalid.
No, I mean further in the future.
No, yes, they can.
Even though I'm up.
Yes, they can. You did not comply with the order. You owe them over $11,000. You came in here and told me, do I have to repeat this again? You came in here and told me the only payment that wasn't made was in May, and that was not true. Now, maybe I'd find it in my heart to figure out a way to help you a little bit if you didn't lie to me. This is a courtroom. We're not in a bar. No, they can garnish. You gotta be more upfront next time. Good luck.
And there it is, a textbook example of how courtroom credibility can collapse in real time. At the heart of this case is a simple civil debt judgment. The court ordered monthly payments of $266 starting in May. The defendant walked in confident, insisting he was up to date, blaming missing paperwork, and arguing that the first missed month wasn't his fault. On the surface, it sounds reasonable. If you don't receive the payment instructions, how can you pay correctly? But the judge immediately points out a crucial legal truth. Even without perfect instructions, the obligation to pay still exists. The responsibility to set money aside and comply with a court order never disappears. Then comes the financial reality check. When the plaintiff's attorney presents the actual payment history, the story changes. Instead of monthly payments beginning in May, the first recorded payment appears in August. Only 3 successful payments total. 1 bounced check, and months with nothing at all. That's when the judge starts doing what he calls pulling teeth, asking direct questions, re-asking them, and stripping away vague explanations until only facts remain. The defendant tries to recover by revealing a last-minute $1,300 payment, hoping it proves good faith. But timing matters in court. A lump sum paid yesterday doesn't erase months of non-compliance. And when the judge compares what the defendant first claimed, I only missed 1 payment, to the record showing several missed months, the issue shifts from money to honesty. That's why the judge emphasizes misrepresentation. In legal proceedings, misleading the court damages your position more than the original financial mistake. Legally, the ruling is straightforward. Because the defendant failed to follow the original payment order, his objection to garnishment is denied. The writ of garnishment continues. All withheld funds go to the plaintiff, and future garnishment remains in effect until the debt over $11,000 is satisfied. No negotiation, no reset, just enforcement of the existing judgment. But beyond the numbers, this hearing highlights something bigger. Courts expect transparency. If a defendant had walked in and said, "I fell behind, here's why, here's what I can realistically pay," the judge might have explored alternatives. In fact, the judge even admits he might have tried to help if honesty had come first. Instead, conflicting explanations, shifting stories, and selective truth close that door. So here's the question for you watching at home. If you were in this situation, would you have admitted being behind from the start or tried to talk your way out of it? And do you think the judge was fair, or too tough? Either way, this case reminds us that in court, paperwork doesn't forget, payment records don't lie, and credibility is everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.